Good morning, distinguished guests, speakers and participants. It is lovely to gather here with fellow lawyers on a Saturday morning. It is my absolute pleasure and privilege to welcome you to the first session of the Bengaluru ADR Week 2025. I paused there for applause, so I'm hoping that will come. Thank you. We're very pleased to begin our first panel today, which is also the largest panel for this weekend, which is on arbitration in real estate, the pitfalls, innovation and future trends. We invite our distinguished guests to join us on stage, please. Honorable Justice Shri Suraj Govindraj. Honorable Judge of the High Court of Karnataka, Justice Govindraj has a rich and diverse background in real estate disputes, having represented several of Bengaluru's leading developers in contentious disputes and having advised them on a variety of real estate matters during his illustrious career prior to elevation to the bench. As a judge, Justice Govindraj has laid down considerable precedent on real estate-related issues and land-related disputes. We could not think of a better chair for this panel today. Mr. Ratan Singh, a senior advocate who's joined us here from Delhi, is the first ever international member of Keating Chambers, London. He specializes in high-value engineering, construction, infrastructure, and mining commercial disputes. He is the founder and chairman of India Branch of Society of Construction Law UK and director of India Branch of Chartered Institute of Arbitrators. He is empaneled as arbitrator with many international and domestic arbitration institutions such as the Singapore International Arbitration Centre, AIAC Malaysia, ICA, DIA, etc. He regularly represents parties and sits as arbitrators for engineering, construction and commercial disputes. Mr. Singh is also honorary professors of Manipal Law College and Dhirubhai Ambani Law College, apart from a visiting faculty of OP Jindal University. Thank you so much, sir, for joining us today. Mr. Srinivas Raghavan, a senior advocate based out of Bangalore. Prior to his designation as a senior counsel, he was heading the litigation practice of the then firm Indus Law. With a career spanning over 20 years, Mr. Raghavan has appeared in several complex disputes for Indian and multinational corporation, specifically for several large builders within the state. Known for his astute and practical approach to dispute resolution, we're happy to have Mr. Raghavan join us to share his views today. Thank you, sir. Mr. T. Arvind Pai is the former Executive Director Legal of the Prestige Group. In his career spanning over 30 years at one of Bengaluru's leading construction companies, he has advised on several complex land transactions and disputes. Sir, we are honored to have you here with us and look forward to hearing your perspective on arbitrating real estate disputes. Mr. CVK Reddy is a former Indian Engineering Services officer of the 1983 batch. He has over 4 decades of experience across the government and private sector and as a special class contractor in project management, value engineering and construction of infrastructure and real estate projects. As a techno-legal counsel, Mr. Reddy has handled over 40 arbitration cases, primarily in infrastructure contracts with infra companies, various CPSUs, central and state government departments, and real estate developers. Thank you for joining us today, sir. We look forward to hearing your views. Ms. Sanjana Rao started her career at a leading full-service law firm in Bangalore and has thereafter co-founded R&A Partners in 2025. With several years of experience behind her in civil litigation and alternate dispute resolution, Sanjana regularly represents clients before various forums in Karnataka and outside. Thank you, Sanjana, for joining us today. I will introduce a little bit about the topic, of course, before we hand over to the panelists here. The real estate landscape is growing and expanding today, and also one of the most dispute-heavy sectors in this economy. A lot of the real estate disputes that we see vary from construction delays, cost overrun, land acquisition disputes, which are now, of course, part of it is statutory arbitrable under the NHAI Act. Complex modern projects, of course, and buyer grievances. While tribunalization of certain types of dispute has granted some relief, Certain complex modern projects involve issues that are technical and often require expert consideration, which arbitration could potentially provide. We would, of course, also like to hear the panel's thoughts on what we could do about the large number of partition suits and other pending real estate related disputes as well, and whether ADR is an outlet that can be used. Are arbitration clauses in such disputes useful to parties, and what are the potential challenges? I'll hand over to Honorable Justice Suraj Govindraj, who will be chairing this session. Thank you.
Good morning. Good to see a little number of people in the morning on Saturday. Saturday normally for lawyers is to take it a little easy and start the day a little late, because during the weekdays it is completely hectic. The topic that has been curated today, there are quite a few topics which have been curated by the organizing committee, and I commend them for the topics which have been curated. These are very much in tune and very much required for practicing arbitration professionals and arbitrators. This particular topic of real estate, which has been there, most of us know that most litigations are structured or around real estate. Whether you call it an injunction suit, whether you call it a recovery of possession, restraining of possession, specific performance, partition, name the kind of suits which come up before you as a litigator or we as judges. Most of them are attuned towards real estate. Arbitration is the alternate dispute which is available where parties could agree for settlement or adjudication of their dispute through a private forum. This particular topic becomes more relevant if these suits which are before the court can be adjudicated by an arbitrator in the time-bound manner with the time imposed of 1 year restriction on the challenge to it. There could be a faster adjudication. But however, this has also got a little more complicated because there are a lot of engineering and construction contracts which have come about, where arbitration is as regards those construction contracts where technicalities are there. That is where we have the experts today who will be speaking of the new paradigm of real estate arbitration, arbitrability of real estate disputes, technology to be used in it, and the client expectation from a client perspective. So without much ado, I'll request Mr. Srinivas Raghavan to start on the arbitrability of real estate disputes.
Thank you, sir. So, the original assumption has been that real estate disputes are not suitable for arbitration. Your typical reliefs of declaration, cancellation, such kind of things are not some things which the arbitrators can grant. But then the Supreme Court has paved the way for these kind of disputes also to be arbitrated upon. It has been clarified recently that reliefs such as declaration or cancellation of documents, even conveyances, are not in the nature of interim proceedings, but they are in-personal proceedings. And therefore, that could pave the way. Of course, there is still hesitation for people to try out arbitration in that. But since arbitration is a creature of consent, perhaps from the agreement stages where these clauses are incorporated, we could see a growth of arbitration in relation to typical real estate disputes, including declaration of title, cancellation, etc. As of now, of course, we have always seen there was some doubt about arbitrability of lease disputes, so that has been cleared, that has been put out of the way by the Supreme Court. So right now, we are seeing the kind of disputes which are coming up in real estate, landlord-tenant disputes, where there are clauses in the lease deeds, eviction, injunction, damages in relation to landlord-tenants. We see those kind of disputes now being routinely arbitrated upon, and the people are seeing that perhaps eviction could be faster if you resort to arbitration than the typical civil suits. And we are seeing a lot of disputes around lease and sale agreements, including specific performance of both sale agreements, lease agreements, especially when you take leases of, let's say, commercial spaces, where there are agreements to lease entered into at the construction stage, and then there are disputes which arise. We see those getting into arbitration with again claims for specific performance damages, etc. Then, of course, especially in Bangalore, you will see that where there is development activity in the upswing, a lot of joint development agreement related disputes between the owners and the developers. It could be residential projects or even commercial spaces or even layouts. So we are seeing increasingly these disputes again about specific performance, validity of termination, damages, loss of profit. There are issues regarding, especially where there's revenue sharing which is involved. We are seeing disputes around that. Adjustment of monies between parties in the course of transactions. Interestingly, we are seeing a lot of GST related questions also coming up in arbitrations. So therefore, perhaps some questions regarding GST have to be decided upon by the arbitrators, of course, which have a bearing on the contractual rights and obligations of the parties. Then, of course, liquidated damages. These are routinely coming up in JDA related disputes. Now, the other area which is now, of course, where RERA has come in, and we need to see arbitration post RERA. Prior to that, developers used to have routinely clauses in their allotment agreements or allotment letters or booking forms or agreements of sale where they would have arbitration clauses. But now, to some extent, already a dent had been made by the Consumer Protection Act because housing was considered as a service and allottees had started resorting to Consumer Protection Act proceedings. And the Supreme Court had made it clear already that since the Consumer Protection Act is an additional remedy which is given, an allottee or a purchaser cannot be compelled to go for arbitration. Now, in addition to that, we have RERA which has come in with a whole lot of new rights, obligations created with specialized tribunals. So this is part of the tribunalization process which has taken place, and we have seen historically wherever new rights, obligations have been created with remedies being given in terms of creation of tribunals, fora, that the Supreme Court has taken the view that these may not be arbitrable. Now, interestingly, post-RERA, we are finding two sets of views which have emerged. For example, the Bombay High Court has taken the view that in the light of specialized fora and rights and obligations being created under RERA, these are non-arbitrable in that sense. But there are slightly different views taken. In fact, we have seen cases where, for whatever reasons best known, the allottees have sometimes chosen arbitration over approaching RERA also. So the question has arisen whether the allottee can be, and the developer has taken the view that no, you should not resort to arbitration because it's considered non-arbitrable and therefore you are bound to go to RERA. And a couple of high courts have taken the view that no, it's the choice of the allottee where he wishes to go. If he chooses to rely on the arbitration clause, then RERA is an additional remedy and therefore he cannot be barred from going to arbitration. So now this presents one opportunity where we could perhaps see some parallel proceedings where, for example, a promoter may feel that RERA is not meant for him, but I should say that the RERA Act in a way allows promoters also to raise their dispute before the RERA forum. But let's say a promoter is at the receiving end of certain claims from allottees, and if the allottee chooses to move RERA, the promoter may say, well, let me try to invoke the arbitration clause and try to create parallel proceedings. It could be around the same set of facts and perhaps questions. Usually, typically, the allottee would say that there has been delay in handing over of the project or whatever it is, and the promoter would say there are various reasons why it has not happened, and he may also put some blame on the allottee for non-payment of the monies as and when they fall due, etc. So there could be attempts where the promoter could say that, hey, RERA is not a remedy for me, and therefore I have got a clause which provides for arbitration, and you could have a situation where the allottee moves RERA and the developer moves for arbitration. There has been an instance of this kind of thing where the Supreme Court has, I must give you an instance. For example, this happened in the Consumer Protection Act, where the Allotee had started proceedings under the Consumer Protection Act, and the developer sought to file Section 11 proceedings for appointment of arbitrator. And the Allotee came to the High Court and said, look, but I have already moved the Consumer Forum. And the High Court said, okay, I will not appoint an arbitrator. And that was upheld by the Supreme Court, saying that no, we cannot have this because Consumer Protection Act is for the benefit of consumers. And even though the builder is not a consumer and therefore he cannot raise a claim on the Consumer Protection Act, still he is barred from resorting to arbitration. So whether that will be followed in these kind of cases where the promoter resorts to arbitration to counter RERA proceedings needs to be seen. But again, there are these other cases where the allotee has chosen arbitration over RERA. So perhaps the promoter could say that, look, why should it be that he gets a choice to move either arbitration or RERA, but I do not get the choice to move for arbitration if there is a clause, it is agreed. So these are potential areas of dispute which we could see. And we cannot even rule out inter se promoters issues. Again, there could be parallel proceedings. But you see, the RERA typically provides for adjudication on rights and obligations arising out of RERA. So, but then we cannot, if there are timelines and there is a registration made by a promoter in RERA where he has promised that some development will be done within a particular time frame, we can't rule out because a landowner also would be treated as a promoter. So he may even resort to RERA insofar as the developer is concerned, and these normally the joint development agreement would have arbitration clauses, and then we could see again a possibility of the promoter resorting to or the developer resorting to arbitration. So these are potential areas which we will see emerging in terms of the interplay between RERA and arbitration. But to a large extent, inter se promoter, that is between the landowner and developer, we would more be seeing of it only in arbitration in terms of the disputes. And I would say the trend would be that in terms of the allottees, more or less they would be approaching RERA because you see a RERA dispute or a promoter allotee dispute would start involving lot more of people. It could be an association of allottees, it could be banks, financiers would be involved. Therefore, an arbitration may not really be the situation to deal with those kind of disputes. The Supreme Court has made it clear that proceedings which have erroneous effect may not be arbitrable. And even way back in Booz Allen itself, it had been made clear that mortgage-related disputes are not subject to arbitration. So these are issues where we will see that arbitration may not be the forum which is resorted to. And when it comes to completion of projects, naturally the RERA gives wider powers on the fora which are created under RERA to pass orders, whereas we know that insofar as arbitrations are concerned, courts have held that the arbitrators are creatures of statutes and therefore they cannot go beyond them. And therefore, in terms of the reliefs that they can grant or order, it will be confined to those which are provided under the normal law. So it's going to be, I would say, an interesting time ahead where we could see this interaction. Incidentally, I must point out this scope of parallel proceedings. We have some example of that which has happened in DRT proceedings. For example, where the borrower has filed a civil suit against the bank alleging this. So the Supreme Court has said, yes, that's fine, even though the borrower is allowed to make a counterclaim in DRT proceedings. That does not bar him from resorting to arbitration, to a civil court. So if he can resort to a civil court, he can resort to arbitration also when there is a clause. So these are issues which are arising. Some of the courts have said the RERA provision which bars jurisdiction says it bars jurisdiction of civil courts, and an arbitration is not a court, and therefore they have allowed allottees, in the context of allottees, they have allowed arbitration to start. But it is unlikely that they may favor promoters resorting to arbitration with a view to get over.
Let me just, senior counsels cannot be stopped from arguing.
That is the utmost appropriate person to do so.
Let Mr. Raghavan speak, he'll be speaking till cows come home at the end of the day. Unfortunately, we are limited by time. The session is only till 11:15. Each of the speakers, let me remind, is given only 6 minutes. So please try and retain the 6 minutes. to just give a context of what Mr. Raghavan is speaking, why is this required? I'll just ask you a question. Let me see what the answers could be. From 1st January 2015 till 31st December 2022, can you guess how many litigations were filed, both civil and criminal, in all district courts across the country? Any guesses on that? Across the country before the district judiciary. I'm not speaking of the High Court and the Supreme Court. Any guesses? No guesses. Nobody wants to take a guess also. 4 crores. Any other guess? I'll give 3 guesses. Any other guess?
10 crores.
10. That's a substantial improvement. Any other guess?
25,000.
25,000. This is the reason why I asked you the question, is that without knowing the context of why arbitration and why we need to move to arbitration, it will be difficult. We have a wide-ranging answer between 25,000 cases across the country to 4 crores across the country to 10 crores across the country. The number is actually 11 crores 77 lakhs. There are 11 crores 77 lakhs cases filed between that block period of 7 years. Now can you guess how many cases were disposed?
11.
1 lakh. Who is that person who said that? You hold our judiciary in very low esteem. Content will be
11 crore.
11. Threat of contempt was very vague. Anybody else? 9 crore 97 lakh cases were disposed. The disposal, or what we call the case clearance ratio of 85 to 87% has been the standard among the district judiciary. It's quite a sizable number. But unfortunately, we also did accumulate 1 crore 77 lakh cases. And that keeps on accumulating. The reasons may be many, we are not here to deliberate on the reasons. But one of the ways that we can, now that we have also come to set a context that litigation is more in respect of real estate, and if real estate litigation before the courts can be handled by arbitration in a faster manner, the arbitrability will always be tested, whether this is arbitrable or not. That remains to all the lawyers to use their legal acumen to push the bar to say that this is arbitrable and this is not arbitrable, and at some point some court will decide in favor of arbitrability or against arbitrability. But pushing the envelope is the lawyer's job, as always. So what Mr. Raghavan put across, so many conundrums which are there as regards this being arbitrable, that being arbitrable, parallel proceedings being initiated. This conundrum would continue, and we need to see how many could be pushed towards arbitration and how many could be said that these are not arbitrable in a clear manner, so that the litigant and the lawyers and everybody knows that there is a transparency and there is a permanency in that particular aspect. Thank you, Mr. Raghavan, for highlighting this particular aspect of arbitrability which goes to the root of the whole matter. Now let me come to Mr. Ratan Singh, senior advocate from Delhi, who has tremendous experience in engineering and construction contracts and technicalities involved therein. Without much ado, Mr. Ratan Singh.
Good morning, Lord Justice Suraj, my co-panelists, ladies and gentlemen. We are not used to early morning conferences in India as yet. But good to see so many of you here. On what was just said about real estate arbitration. In fact, some time back, I was invited to speak in Labashna, IS Academy in Sweden. And there they had organized a national conference where all heads of revenue boards and people from secretaries from revenue departments from all across the country had come, and I was asked to present a paper. There I had suggested ways and means to have arbitration For revenue disputes, which we immediately say, no, you can't, land disputes can't go to, it is fight between about the, who owns this side of law and measurements and all of that. And that was taken up with all seriousness. It was sent to the Government of India Ministry and they must be looking at it. That is one thing. I have been asked to talk about construction arbitration. We all are very enthusiastic about arbitration. But if you see the statistics, around 60%, minimum 60% of arbitrations in India are construction, engineering, oil and gas arbitrations. ICC Paris in its data says that 40% of, which is the world's biggest arbitration institution, they say around 40% of their arbitrations are again construction, engineering, oil and gas. But question is, in fact, some time back I was in Singapore, I was speaking in a conference, it was a CL international conference. And I was asked 3 questions during my entire talk. First question was, do you teach construction law in law colleges and engineering colleges? Second question was, do you have construction laws and legislations in India? And third question was, do you have a specialized construction courts? And ladies and gentlemen, answer to all the 3 is in negative. We don't have construction legislations in India like other jurisdictions. Justice Suraj will be telling you in courts. Invariably, we come across disputes like back-to-back contracts and so on and so forth. The main contractor has got the payment, but he has not paid to the subcontractor and so on and so forth. All across the country. And most of the disputes, whether it is typical real estate disputes, I have been engaged in many matters where big builders and developers are the parties. They got their construction. They are in dispute. Now, globally, and particularly in all developed jurisdictions, you have construction legislations which ensures that payments are made regularly to the contractors and subcontractors and work is getting done, it is not getting delayed. So you will have adjudication processes which is called security of payment legislation. In UK, you have housing grants. You have such laws, SOPs, we call SOPs, you have in Malaysia, you have in Singapore, you have in New Zealand, you have in Australia, you have in US. But we don't have any such legislations. We are talking about, we are raising this issue with stakeholders. Let's see what happens. Another issue is that we do not have technology and construction courts, specialized courts, like technology and construction court in UK. Every other jurisdiction, I was just talking to Justice Suraj. I was in Malaysia. Last 3 months, I have gone there twice to speak on construction arbitration. They all have construction divisions in their courts. In fact, in Singapore, a few years back, I was there and I'm part of International Academy of Construction Lawyers. So we were there, we were invited to Supreme Court to give talk to their accredited construction lawyers. So what Singapore Supreme Court does is this. They give accreditation to construction lawyers. And then from them, they take some of them on the bench. Now, beauty of this is that because this recognizes one fact that construction arbitration is a different breed of animal. It requires a specialization. It requires a different set of a skill set you need to work on. And then they give accreditation. Now, we again need to do that. So far as teaching construction law is concerned. Now, we all have arbitration weeks in India all across the country. But what we do in typical arbitration conferences is, we tell you what is arbitration, how it works, who are stakeholders, what is good, what is bad about arbitration. But if you know that 60 to 70% arbitrations are construction arbitrations, and you know that it requires different kind of a skill set and training,
can you really pursue arbitration, construction arbitration, without knowing that there is something called construction law, which has got very developed jurisprudence, and it requires a special training. Now, we do not teach construction law. It is like telling somebody, some lawyer says that I know CPC, I know arbitration, therefore you come to me. No client is going to come to you just because you know CPC. Similarly, just because you know arbitration, nobody is going to approach you. So therefore, to do a particular kind of arbitration, you must have a specialization in the subject matter. That is what is important. That is what I wanted to convey. Second thing is, teaching construction law, it has got very developed jurisprudence. In fact, unfortunately, in India, we do not have developed jurisprudence on construction disputes. We are still following the English laws and US laws or other common law countries, whatever the law they have. In fact, everybody talks about Unibros judgment of Supreme Court and Bartley Boy judgment of Supreme Court, where those formulas are recognized and all of that. Now we are getting happy now. And this has been the law for donkey years all across the globe. And there are so many areas where it is just complete absence of law. What is the result thereof? Result is that the consumers of construction arbitration or people from industry, contractor or employer, they have problems. Their expectations are not being met. Construction arbitrations are being treated as one of those commercial arbitrations where most of the time it is guesswork. So expectations are not met, and the result is that people are getting a bit worried about arbitration. Like last year, Government of India came out with a notification circular saying that we will not have arbitration for government contracts. It is all because of quality of decision making. Quality of decision making is such because we are not training ourselves and recognizing that there is something wrong. I'll give you one simple example and I told this. Most of the disputes all across the world for construction, engineering projects, airport, whatever, is related to delay. Now, delay, and typically with Indian arbitration, I sit as arbitrator, I appear as counsel. Suppose there is a project which had to get over in 2 years and it had taken 6 years. Contractor will say entire delay of 4 years are on the head of the employer. Employer will say that entire delay of 4 years are on the head of the employer. They will not give any concession to each other. They will not even say that there is some period where there was some concurrency where both sides did. Nothing like this. Now, what they do? Contractor will say, you did not give me approval for this window panel drawing, for this terrace, slab casting and so on and so forth. All of the period, they club it and they put a case against it. Arbitration against it. Now, in construction law, in construction jurisprudence, all delays are no delays. There are multiple heads of types of delay. There's something called excusable delay, where delay is entirely on the head of the employer. Therefore, contractor was excused from delaying. There is something called non-excusable delay, where it is all on the head of the contractor. There is something called concurrent delay, where both sides are delaying together within the same period window. There is something called compensable delay, where even if it is excusable delay, where delay is on the head of the employer, whether that can be it is compensable and whether contractor can be compensated or not, that becomes a matter of contract. There is something called non-compensable delay. And most important thing is, as I was giving an example, only one example that will really clear many of the dots. In construction industry, construction law, every delay is not delay. How I say this? Let us assume that this 4-story building was to be built and employer had to approve the drawing. If employer does not approve the drawing for this ground floor slab casting, can contractor go ahead? Answer is no. Unless you approve the drawing, I cannot go ahead and build the first and second and third floors. But what happens if employer delays in giving an approval for grant of this window panel of the ground floor? Can contractor go ahead or not? Answer is yes. But what contractor will tell you that you delayed for 3 months here, you delayed 3 months here, so you delayed for 6 months. No. Till the time you had time to complete the work and you had time to do this window, which suppose it takes 15 days. So this is no delay. It means those delays which are critical in nature, which falls on the critical path of the project, can only shift the date of completion, not all delays. Look, let's talk about highways or expressways. What happens? Contractor says you had to give the possession within 120 days. You have taken 6 months in giving me this entire possession, and everybody is fighting. Now, assuming that there is a contractual stipulation that you have give the possession within 120 days, suppose it has not been given. So long, it is a linear project. So long as contractor had workable stretch available, he is supposed to work. He cannot say, I'll not work because you have delayed. Right? You import the principles of section 73 of Contract Act, mitigation. So mitigation of loss, what section 73 says, and globally it says, mitigation of delay also. So this is how, and how do you, in fact, I founded in India Society of Construction Law, which is the India branch of Society of Construction Law. We have all across the globe Society of Construction Law. We have got a protocol called SCL Delay and Disruption Protocol, which is used globally by all courts. Not in India though. In other countries it is being used. Every delay and disruption expert, quantum expert who are cited invariably in all construction disputes will rely on this protocol. Every literature on construction law refers to SCL Delay and Disruption Protocol. If you have interest in construction arbitration, just download it from SCL India website. It is freely available, or SCL UK website. It is around 80 pages. It has got glossary. So like you carry CPC, if you want to pursue construction arbitration, you must carry that SCL Delay and Disruption. And last thing, in order to start construction, teaching in construction law, we got initiated first LLM in construction law in Bengaluru, in Manipal Law College. We got started certificate courses. We got started PG diploma courses. And it is going like anything. I am the chairman of the advisory committee. I am honorary professor. I come, or otherwise online, I teach. This is my passion. Second thing we started in Dhirubhai Ambani University. So here you have online courses, certificate courses, so that you can think like engineer. So that tomorrow some delay expert doesn't come and just try to play around you. And I have also, I'm teaching credit point course in OP Jindal. We are teaching I'm teaching construction arbitration. So my only statement, as a last statement, would be construction law is a different breed of animal. If you want to pursue arbitration as a career, you have no option but to take some kind of learning, structured learning in construction law. Recognize that it is a specialized subject. There are many books available for that. You can take it forward. That should be a good additional career, if not the alternate career. Thank you very much.
Thank you, Mr. Singh. Education is the foundation for everything. And here training could also be, apart from education, by way of training, by certification is what Mr. Singh has brought home. Now this training, to just put it again in context, would be training for the lawyers, training for the judges, training for the arbitrators. Unless this training were to happen to consider engineering and construction contract, which is a real estate contract, because it is a construction on a land which is real estate. Otherwise, it is not a real estate contract per se. Just because the construction is happening on land, which is a real estate, it becomes a real estate contract. But this kind of construction contracts today, with the nature of infrastructure projects which are happening, are mind-boggling. It is a metro. It's not a small house construction. It's an apartment complex of 4,000 apartments, 3,000 apartments, 10,000 apartments. It is a mall. It is a construction of a factory. It could be so many constructions which could be there. It could be the highest viaduct to be constructed. But do we have the expertise and experience as a lawyer to conduct that kind of an arbitration? Do we have the patience and do we have the ability to listen to the technical people who are briefing us? Would the arbitrator or the judge be in a position to understand these nuances? And how do we do this? Training is what Mr. Singh spoke of. 2 of the colleges have these courses. Thankfully, they are not full-time courses. Many of you could take it up along with your career. Probably the organizers could dwell on this point of training as regards how arbitrations could be conducted in these specialized, nuanced arbitrations, and what kind of training are available for these kind. It could be captured and circulated in the report that could be given by Mr. Sriranga or the organizing committee. Thank you. Now we have Mr. Reddy, who is a technical arbitrator who has had tremendous experience on the technical side of arbitration. Why this is important is there is a judicial side and there is a technical side. Many a time we see that the twain doesn't meet. The judicial procedure is different, technical procedure is different. For a technical arbitrator is 2 plus 2 equal to 4. And it stops there. But for a lawyer or an arbitrator or a judge, 2 plus 2 could be 3, 4, 5, 6, 22, because it is how it is interpreted, how it is placed, and how logically it is presented. But to have the technical arbitrator's perspective, we have Mr. Reddy. Mr. Reddy.
Raj, Shri Ratan Singh ji, and my co-panelists. I thank the organizers to give me this opportunity. We had courts where we could litigate. We had, is it audible?
Yes.
Yeah. We had advocates, lawyers who could argue the cases in the courtrooms. We had judges who could pronounce judgments or resolve disputes in the courts. Then why did this arbitration came into the arena? The main reason is in commercial or construction or in any business, the disputes have to be resolved very quickly. In litigation, the judgment has to be perfect, like a title of a land. It has to be, you get the title or you don't get the title. It is 100% or 0%. But in commercial and a business purpose, it need not be 100%. What we need is some approximate purpose. It should not shock the conscience, what is stated in the interpretation of section 34 and 28 and all that. So the purpose is quick decision. I've been a contractor actually. I've been in IES, then I took up contracts. Then I'm a live example for how, as a contractor, I failed. Now I've turned into an advocate. I'm helping other contractors and other firms. So it's a pure live example. I took up contracts. Though I'd not participated in arbitration while I was in service in the IES and all that, we didn't take as usual, that seriously. We don't go into the depth because we're not totally affected. That's but human. When I became a contractor, I knew that I was not doing anything wrong, but I'm suffering. I'm bleeding. Financially, I'm bleeding. So this is where the arbitration comes in now. You have to stop the financial bleeding. You cannot wait for this patient to go to ICU, then I will rectify that. By then, he will be totally ineffective. He may die also. After that, you give the money to him. There's no business. That's what exactly happened to me. Now I took a different profession. Now I become a lawyer and I'm helping infrastructure. This is what. So the essence should not be forgotten. That means you have to give a quick solution. It may not be a perfect solution, unlike in a declaration of a title. I may not be using the correct words because I'm not a perfect lawyer or perfect advocate. A property, somebody owns it or somebody doesn't own it. It's 100% or 0%. But in construction or in business, I have to get 1 crore. But if I get 50 lakhs now, I will survive. If you don't give me a 1 crore now and after 2 years with interest of 7%, 8%, that's the mindset of our arbitrators and our judges and all that, because they're bound by that interest act. 6% is the ceiling. Arbitration Act doesn't put any ceiling. It provides trade practices actually, but still they're bound somehow or other. No, 8% is reasonable without any rhyme or reason. But 8% after 10 years is nothing for a business purpose. He borrows money at 12% or 18% compounded monthly, but you give his money after. He's supposed to pay that service, that interest, service, that loan at that person, make a turnover, make a profit, employ people, and then create infrastructure, create employment. But that is the mindset, it has to come out because now the quick fix solution, that's what we have to find, not a perfect solution. So how do we do that? What are both the judgments in a litigation and then the arbitration award in a construction through an arbitration? It has to, base on 2 grounds. One is the legal grounds, other is the merits. That's what. So as I mentioned, the threshold or the bar for a judgment is very, very high. In fact, it has to be 100% because it is subject to strict scrutiny in appeal stage. Whereas in arbitration, to give a quick solution to the problem, they've given a lot of flexibility in the judgment. So the flexibility is so much. Now, if you interpret section 28, 34 as interpreted by Sangyung judgment, the legal requirement is so low. You follow the principles of natural justice, that is bias, or you hear the other party, then you give the reasoning. I feel that it meets the requirement of the legal. The Sangyung judgment goes to the extent that you violate statutory law, still it will pass through section 34. But unfortunately, we go so much into the law because it's all practiced mostly by the lawyers and judges and all that, the CPC, the interest acts and all that, they come with all that baggage. So that has to go. So this is like, the clearance from the legal perspective is like in the entrance examination, we have got 2 types. One is the, let's say, languages. You have to clear the minimum bar. After that, your merit is decided by your subject. Your merit is based on the subject. So here, you clear these principles of natural justice. This is not a big law in arbitration. You just clear the principles of natural, you're through, basically. So you're passed in that. Once you pass that, now your effort should be to get the best possible guesswork, best possible judgment. Let's have to get 1 crore. You give me 50 crores. I mean, it has to shock the conscience of the court. That's what, then only you can interpret it. So you've got so much of leverage, so much of flexibility in deciding the award. So but what happens is, we bring the CPC, we bring all, to the extent that when there are no documents which are denied also, the lawyers, sorry if I'm using it, but that's what is practically happening. I've experienced when the opposite parties are represented by law, they will file an examination in that affidavit in examination in chief. They are not proving any point. They're just repeating the whole pleadings and all that. What is the purpose of that examination chief is lost, basically. I have not denied any of those documents. We have to argue based on the content of those documents. But no, they will invariably file an examination in chief, irrespective of what fact they want to prove. And then we have to do cross-examination. It's getting delayed. The purpose is defeated, actually, the arbitration process. You have to get the quick solution. That is whatever we may do. We have to do that. It's like, you're not playing a test match with unlimited days and all that. You're playing T20, you have to go. Day 1, somehow or other, you'll have to get a quick 30 or 40. If you say, no, I'll play that, Rahul Dravid style, copybook style and all that, that doesn't work in an arbitration, basically. So what is required most is, more than the legal expertise in arbitration, you need technical expertise. You cannot, actually, the provision in the Arbitration Act, which says that the arbitrator can get an expert witness by himself and all that. That should not be the case. The arbitrator should have, must have, then only he should become an arbitrator, in my opinion. I may be harsh here, but that is a fact. That's what I've experienced as a lawyer, as a contractor, as a government employer, as a private employer. My suggestion is, without expertise in the field, however you may get it, through practice, through education, or through degree and all that, without that, I mean, it should not be, I mean, you should have, then only you will get a correct decision. Thank you, sir. I think I may become a bit emotional because I'm not used to.
Didn't I say 2 plus 2 equal to 4? Didn't I say 2 plus 2 equal to 4? And T20 it became. So, this is what the contractor or the employer would. One of the person always wants to delay. The reason for delay in most of the litigation in the court is not just because of the delay on part of the system per se, but the judiciary per se, but it is because one party wants to delay the proceedings. So long as one party gets a benefit on the delay, there is a delay which will happen. Now, as Mr. Reddy said, I've asked for 1 crore, but give me 50 lakhs now. Or 100 crores, give me 50 crores now, whichever it is 50%. The rest 50% you debate later. Of course, the Arbitration Act has emergency provisions where these kind of actions could be taken, but are they being taken? What is the practicality of it? The legality of it is one, the practicality is the other, is what Mr. Reddy is speaking of. And what is the point if the contractor were to go down and he declares bankruptcy? What is the point in having an award after bankruptcy? These are serious issues which, as Mr. Reddy said, he got emotional because it is such a serious issue. Finally, the entire system for the judiciary or for the arbitral system is for that litigant. Without that litigant, we as judiciary or as arbitrators have no other role to play. And if we are not able to cater to that particular litigant who has that trust, again going back to my earlier this one, why did 11 crore 77 lakh people come to court? Because they have the trust in our system. So we need that trust to be continued. And if arbitration has to progress, that trust in arbitration has to be there. And for a person, as Mr. Ratan Singh just said in his talk, that people have removed the arbitration clause. Why have they removed the arbitration clause? If you look at, both of them spoke differently on different aspects, but if you look at it, it's basically the trust in that arbitration system. That needs to be looked at, and one of the aspects could be the training, which again binds both the issues. If the arbitrators are trained properly, if the arbitrators are not hyper-technical or hyper-legal, but legality cannot be given a go by, finally the award has to stand the test of law. But what could be done? What are the ground rules which could be laid? That is something which is out in the open for deliberation. I am not saying this way or that way, but this is a perspective which has come up from Mr. Reddy, which that perspective has to be given its due preference. Mr. Ratan Singh also had mentioned during his talk as regards technology and how there has to be a guarantee for payment, etc. One of the issues, most of our contracts are executory contracts. Technology has now come in with smart contracts. There could be a smart contract which triggers off various aspects of it. It could be payment, it could be approval, it could be the various aspects which are there in a contract. A smart contract is a self-executory contract, it's an algorithmic contract, and technology is pervading into contracts. Now, to get into technology and contracts, we have Ranjana, who is going to be speaking to us on technology and arbitration, technology and contracts. Thank you, Ranjana.
Thank you. Am I audible? Thank you, organizers, for inviting me for this panel today and being part of this esteemed group. Just to take off from where Mr. Ratan Singh spoke about construction contracts and how the other co-panelists also spoke about different aspects of arbitration in real estate. I think all of us in this room today have dealt with real estate arbitration, particularly construction arbitrations. They are complex and they are voluminous. I don't think I've seen a single arbitration so far where it has been just a few set of papers given to us where we have to study it, prepare our claim or defense, and go ahead into arbitration. Incidentally, the first arbitration that I worked on was a construction arbitration. I think I was barely 3-4 months into practice, and the senior partner of the firm called me in and said, you know, there is a client who's come in and we need to work on this arbitration. It's a construction arbitration, and he's going to take you through the documents. We proceeded to the conference room. I was very excited about it. That excitement immediately turned into anxiety when I saw him keep 2 bags of documents in front of me. I'm sure all of you have dealt with a lot more bags of documents, but for someone who is just 3 months into practice, looking at 2 coat bags full of documents, it gave me a lot of anxiety. It took me about, I think, 3 weeks to go through all of these documents, to organize it, to make sense of it, and then sit down with the senior partner to formulate our claims and defense after that. But today, there is enough technology available at hand to help us organize these documents right from the get-go. And I think this is something that will help advocates save a lot of time. I've done a lot of reading before starting for this panel. So what I found interesting is there are several products across countries in different jurisdictions. There are a lot of people who are using these products to, where they feed in all of these documents into the software. It is then, the software then reads these documents, organizes them either in a chronological order or provides list of dates to the parties to look at. There are even softwares which read into certain complicated documents, because we are lawyers. At the end of the day, our experience is limited to the law. We are not in a position to study Gantt charts. We are not in a position to study complicated drawings that have been executed in these contracts. There are softwares available that read into each of these documents and provide a summary that is easy for a lawyer to understand while preparing for a case. Now, are we using these tools today? That is a big question that is part of a lot of discussions that I've had recently. Are we actually effectively using these kind of tools? Human nature is to sort of resist any change that is coming our way. Technology is there with us, but everyone is very apprehensive to use it because we don't know much about it. But I believe that if we start incorporating this technology into our practices, the more we learn, the more we interact with people who are creating this technology, and the more knowledge we get about it, it will make arbitration, particularly construction arbitration, a seamless exercise for a lot of us. What I found interesting is something as recent as November 3rd, the American Arbitration Association created something called the AI arbitrator. Now, this is a very unique concept where AI is your arbitrator, where both the parties come forward, they file their submissions and their evidence on a platform. This tool will then look into all of the submissions and the evidence that has been provided, and then a draft award is published. This draft award is then vetted by a human arbitrator who's chosen by the association to see if it is in conformity with the requirements. And after that, it's published to the parties. Statistics now say that this AI arbitrator in the last 2-3 weeks where they've experimented with a few of these cases, they have said that it has brought down cost by 50% and efficiency has gone up by 35%. Now, construction contracts, from my experience so far, is predominantly based on documentation. Very rarely do we require a chief examination to be done. Very rarely do we require cross-examination to be done, unless it is something where human involvement was involved. Otherwise, the rest of the time, it's exchange of emails, it is interpretation of the contract, it is the study of drawings, it is Gantt charts and PERT charts. So if we start incorporating technology of this nature into our arbitrations, I think the efficiency will go up. The apprehensions, again, what we have with using such technology can always be answered with more training, more engagement with people who are creating such software to understand it before we start using it, and to always have a human oversight over all of these exercises so that the apprehension of whether the technology is looking at these documents correctly or not can always be supervised by human intervention in these aspects. Another issue I think that people have with respect to including technology in arbitration, because I think arbitration confidentiality and privacy is the biggest plus point. A lot of people do go for arbitration because of this reason. And data breach, cybersecurity issues, and issues with confidentiality, I think, are apprehensions that parties have in contracts of this nature. So if we engage with people who are creating this technology and get their assurance that they're going to give us a robust security system while dealing with these issues, I think things like this will enable technology to help us deal and tackle with these issues much faster, as opposed to having it over, say, a year or two for these arbitrations to conclude. Technology can help us do it in a much quicker manner. So I think that's how technology would probably help us in this arena of construction arbitration.
Thank you, Ranjana. But don't get her wrong. Technology is not going to be replacing arbitrators, judges, or lawyers.
No,
very soon.
absolutely. I don't think any of us want to be
Making it
replaced.
clear
It'll only be an aid in this entire process. I don't think any of us want to be replaced here.
It is just an aid. How many of you have used ChatGPT? Gemini, Grok, more number of ants keep on going up. It's a tool. Your smartphone is a tool that you use. Now, when you say technology, normally we only think of hybrid video conferencing, e-filing, e-enabling the whole thing. I remember Mr. Nananilakani had been invited for National Law School convocation 3 years ago. He made a very simple statement in a speech, which has stuck to me for a long time and probably will remain stuck to me. Transformation we are looking at. What is transformation? Transformation or metamorphosis is what we call a caterpillar becoming a butterfly. So a caterpillar changes into something and becomes a butterfly, which is more beautiful. It's the same caterpillar, it's the same animal actually. But with the wings, we think that it is beautiful, therefore it is metamorphosis into a butterfly. So when we speak of transformation, e-enabling is only making the caterpillar run faster, as what Mr. Nilankani said. It's not a butterfly. It is only e-enabling, making something faster. So what Ranjana was speaking of is a little bit of a transformation from what we are thinking of and what we are doing. We are looking at use of large language models or NLMs to collate the data. As was pointed out earlier by everybody, it is the pleadings which are filed and the documents which are filed in volumes, 10 volumes, 15 volumes, 20 volumes. Because those documents are that thick. The contract, which is supposed to have envisaged everything and not brought about any litigation or arbitration, runs into hundreds of pages. But unfortunately, with that 100-page document, which was never supposed to result in a litigation, 1 clause, 2 clauses, 10 clauses, 20 clauses result in interpretation and brings about litigation. Whether the document needs to be that long to bring about a, not a dichotomy, but a contradiction in terms. Because when we are drafting the document itself, when it becomes longer, it becomes probably a little difficult to make it coalesce and say that this is the sequence of things and this is what it is and there's no contradiction. That is what we do about law also, that this particular provision is contradictory to this, those are the arguments. Now can we do e-discovery of the documents to find out what exactly is the structure and what it has happened? Because the LLM can probably generate a complete list of dates and events and contradiction among the documents and put it across. You don't need to go to 20,000 pages. It flags, it doesn't mean that you have to accept it. It could flag that these are the places where there's a contradiction. And those contradictions could be what could be focused upon by the lawyers and by the arbitrator in the matter. Robocourt, algorithmic judge, AI arbitrator, these are all things which are going to happen in the short future. China has been doing that. We have Estonia, we have got Brazil, who has implemented Prometheus, which is again a fantastic software which looks at what we call substantial question of law. It calls the foundational question. It looks into those aspects and sees whether it's been decided or not. The data in arbitration, when a lot of things are placed before the arbitrator, it could be an engineering contract where there is a particular methodology of construction by that particular contractor, which is brought into this litigation. That particular contractor may not want to disclose the methodology of that particular construction or doing a particular thing. It could be a complicated issue like a sensitive matter. It could be a nuclear reactor. It could be anything. Those data issues and cybersecurity will always be there for these aspects. But could large language models or a model which is built only for arbitration be developed, which could be used, which is different from e-enabling in terms of e-filing, etc., using of AI for that particular purpose is what we could explore upon. This is something that we as lawyers and arbitrators may not be very well equipped to look at. There need to be involvement of specialized, technically trained and technical persons with technical ability in that. It's going to be expensive because AI engineer, network engineer, cyber security experts are not cheap. So we'll have to look at those aspects. Again, as I said, smart contracts, self-executory, that could all be brought about. Now we have a completely different perspective from Mr. Arvind Pai, who is here, who has been associated with the real estate industry for over 30 years, I think. And from all aspects, how real estate has grown in Bangalore from the inceptual stage of a joint development agreement or a 50-80 site on two large 100-acre projects with tech villages, those kind of contracts he has been instrumental in being part of. And he's also, by virtue of that, been part of a lot of litigation, arbitration, etc. I would commend the organizers for curating this panel, because this panel has different perspectives from different people. It is not that everybody is speaking about arbitration from one point of view. You have heard now from different perspectives. But now the final perspective is the client. As I said earlier, we are here because of the client. We are here because of the litigant. What does the litigant wish? What are the pitfalls according to a litigant? What are the things that a litigant want? Over to you, Mr. Arvind Pai.
Thank you, Suresh. Thank you, organizers, for having me on this panel. It has been a true privilege. Yes, indeed. I've spent almost 30 years in real estate, wading through various aspects of real estate, be it due diligence, be it litigation, be it contracting, be it you name it. Probably every aspect of it is being touched upon by me. But my whole experience, with my whole years of experience, one statement, if I can make, is that avoid disputes at any cost. Because disputes are unproductive. It's as simple as that. If it can be resolved through mutual negotiation, mutual discussions, please resolve it. Don't get into any forum, because it's an euphoria at the end of the day. Because it's like when you go to the hospital, the doctors, you can explain the pain, but the doctors will never experience the pain. He will give you antibiotics, he will give you injections, he will give you this, he will give you that. But he can never experience the pain that you are undergoing. I am talking from the pain point, absolute pain point. I've seen litigations. It has never been productive. Maybe for the counsels, maybe for the judges, it's an oratory experience or expressing the words. But at the end of the day, I'm the sufferer. So with that little prelude, I'll just confine myself to the matter on hand, that is arbitration. And I will just rattle out, say a few things about it, so that it kinds of sums up the whole thing. See, arbitration inevitably means you have to have an arbitration contract. Otherwise, arbitration is not possible. So the large gamut of litigations will still remain under the jurisdiction of civil courts. So like litigation of title, litigation of specific performance, litigation of injunction, many aspects, litigation of partition, you name it, there are a lot of things. But to arbitration to happen, you need to really first and the foremost is you need to have an arbitration agreement. If you have an arbitration agreement, the whole process will begin. If there is a dispute. So from that point of view, if I say, as a man on the table is my expectation, there are only 3 points. One is timeline, second is the cost, and the third is the relief. Now, if I typically look at arbitration cycle, it starts with an arbitration notice, appointment of the arbitration tribunal. This, according to my own experience, it will take at least about 6 months. Once the arbitration tribunal is constituted, the proceedings of arbitration itself will take anywhere between 18 months to 24 months if the parties to the arbitration are diligent. If one of the parties is hell-bent upon delaying the whole process, it can be anybody's guess. Now the third aspect is once the arbitration award is passed, the next round of litigation will start. The litigation will be in the form of Section 34 litigation, appeal proceedings in the form of Section 37. So this will be anywhere, if you take it anywhere between 1.5 to 2 years. So on the whole, if you really look at proceedings that is going to happen, an arbitration proceedings happen, to get an executable arbitration award, it is anywhere between 3 to 4 years. Now, the real challenge will begin. Once you get the arbitration award, then you have to execute that arbitration award. So again, you are back to the grind of the court to get it executed. You have to follow all the CPCs. The person who suffered the arbitration effort will make every effort to delay the execution proceeding. On the whole that is in Hindi, it is called maza pura kirkida ho jayega. So you will have only the bad taste left in your mouth of whole of this process. So according to me, that's the reason I started my sentence. Started my thing saying that avoid dispute at any cost because it is unproductive. Any economy or any society to be developed has to be relatively dispute free. Every society which is worth naming are moving towards having a dispute free society rather than how to resolve a dispute. There's a lot of things. We'll have to think like that, so that how we can live with minimum disputes rather than having different forms to agitate our disputes. For example, if you really look at the way this is thing, for a real estate developer, it starts once the land is acquired, there are litigations after litigation filed by the erstwhile landowners or something like that, who say one party is left out, so one partition suit, one party is there, or my land is being encroached upon, there is injunction suit. So this, and so on and so forth. And the moment you go into the actual execution of the project, the RERA comes into effect, the RERA codes comes into effect. Then you have on the one side the contractor who is doing the project, executing the project, so you are constructing the project. If you have a dispute with them, that again is unproductive. It will have counter effect on your delivery schedule. And delivery schedule, if there is a delay in the delivery schedule, you will end up having damages. That damages will not be paid by the contractor. So on the overall, the challenges of doing this kind of a business is much more than actually this. That's the reason I say avoid dispute at any cost. With that, I'll conclude. Thank you.
Thank you, Mr. Pai. Basically, what he's saying is business is already complicated. Don't complicate it further by taking up disputes. So avoid disputes. A lot of lawyers will not be happy with you. Now that he claims to have retired, he can say all this. But this is a fact of life. These are issues which are there. Timeliness of dispute resolution. When we say alternate dispute resolution, it is resolving a dispute. We don't say alternate dispute adjudication. The whole name of it is ADR, as alternate dispute resolution. What we do in court is dispute adjudication or a case adjudication. This perspective of resolution in the earliest possible manner using ADR in an arbitration scenario, whether it could be a med clause or a med whenever it is possible. If there could be a award which could be passed in between with a mediation being successful on a few points not being successful, that possibility of looking at that issue would also would have to be considered. In as much as we refer to mediation, they don't agree on all the points. Therefore, the mediation report comes back as failed. Can we look at a situation where if a matter is referred to mediation, out of 10 points, if 5 points have been agreed upon, could that be taken into consideration and a award be passed by the arbitrator, and remaining 5 could be litigated, as what Mr. Reddy spoke of, as give me 50 crores, don't give me 100 crores. If these 50 crores have been agreed upon, give me. As Mr. Pai was speaking of, is that it takes a lot of time. So the best course is avoid disputes, but avoidance of dispute is not evolution of the society. Dispute is the base of evolution of the society. We need to disagree with each other for us to progress. If all of us were to agree, then it will be George Orwell's 1984, that everything is going to be in that kind of a situation. We are not looking at that utopian situation or a dystopian situation. It's not a utopian, it's a dystopian situation. We are looking at a situation where we progress and we progress further and further, and all progress is based on divergence of opinion. And that basically could probably be a dispute, but we need to close those disputes at the earliest. How do we close it is what we need to deliberate upon and think about. Do you have any time for questions? Yeah, 3 minutes left.
Thank you so much. I think this panel covered a range of subjects from smart contracts to RERA to construction law training, and of course the client perspective from avoiding as well as quick disposal. There's, I think, a huge range that we have covered. We have a little bit of time. We have very short time for questions, so maybe just 2-3 questions. Sorry.
We have just about 3 minutes left.
I think first of all, I'm very glad that AI is not on the panel discussions yet. Right? So I think my question was on the topic of assessing damages in construction contracts and the role of AI, because we all know that when it comes to either the Hudson's formula or the Emden formula, it becomes a little complex. So just from the point of view of the role of damage valuation experts and how AI can be used to test their evidence, I want to understand if there are any trends in AI that would be relevant.
So far as these formulas which you just talked about, these are accepted formulas. Though Hudson formula is a very discredited formula because it has got double content. And you have something called corrected Hudson formula, which removes that profit over profit. So double content. As of now, there are many people, many quantum experts are working on to have something which you have in mind. As of today, we haven't come across any such solution. Whole idea was why this Hudson formula and all of these formulas? Because there is nothing like certainty to really envisage and contemplate the lost opportunity and then therefore unabsorbed head office overhead and therefore profit associated to it. These are all anticipated profits for anticipated loss of opportunity. So it is a complex thing, and therefore the formula. So basically, it was a consensus amongst the quantum experts that this is one way we can deal with it. We have yet to see if we get something better, which can really help us on that.
One day.
Right now, AI is not reached general intelligence. It's expected in 2029, and quantum chips are supposed to happen. But at the end of the day, these are all human relationships, and the way of working on it, there's no perfect mathematical formula, as Mr. Singh said. It's an evolving process. Today it is not there. Maybe another 5-7 years, it may come about. We don't know.
Lordship, may I raise one of the question? Very good, like amply the panel has deliberated on adoption of some of the things like American Bar Association or those kind of proceedings. Because I'm coming from the background where adult capacity or guardianship support for person with compromised capacity. So those kind of things also we are suffering. So what is the challenge in adopting particularly the role model or standard protocol? And lot of educational institution you said, because there are barring one or two universities, consortium of the CLAT, CNLUs, etc. has to also deliberate is what I feel. What do you feel about adoption of these best practices? We are lacking in some ways.
Again, it is a evolving. Two of the universities have now started. It's a start. Somebody needs to start, then thought process will come about, people will think about it, it will evolve. Other universities could start. It is for the Bar Council of India to also think about it probably now, that this could be part of the curriculum, because colleges are bound by what they have to do. There's a little bit of innovation that they could do, which these two colleges have innovated. That innovation is an ongoing process. Probably going forward, changing the status quo is not easy. Change management is not easy. Change management in education is not going to be easy. Adding new, we always keep saying B is not sufficient because it has changed quite a bit. But the course curriculum will take some time. And going forward, it could be, it may not be in the LLB course, it could be a master's course. It's only people who are interested in doing this particular arbitration or contractual matters who would be interested to take up the matter. Everybody would not be wanting to do it. Somebody, the interest could be IPR. So why should I want to do engineering? I want to do corporate, it won't be. I want to do litigation, I don't want to do it. So it's basically the future master's courses. That is where I think the certification courses which has been introduced is amazing. So people who are interested could always take it up. And if there is more demand, I don't see why colleges would not come up with. 3 colleges have come up with. If there's a demand for this particular course, the colleges would only want to make money on that course. So any college will come about with that. There will be people who will be training. Mr. Singh will be training another 100 people who will become trainers. So it's an ongoing process.
In fact, in Dhirubhai Ambani University and Society of Construction Law, I got started one faculty development program where I have selected 60 law professors from hundreds of applications which came. 4 are from abroad, and we have started training them 50 hours class on construction law and construction arbitration. So that is one idea, as you said, that teaching the teachers.
It's already started.
Thank you so much. I think that's all the time we have. May I request Mr. Harish Narsappa from the organizing committee to please come on stage to felicitate our speakers.
Let me end by thanking my fellow panelists. It's been great being with you. Thank you.
Thank you so much to our speakers. I'll just end with a thought. Of course, not a question, but for all panelists and audience. I think when the MSME went under challenge saying mandatory arbitration is possible or not, the Supreme Court said no, mandatory arbitration should be upheld because it's a beneficial legislation and MSME is a beneficial legislation. But when it comes to Consumer Forum or RERA, we have the Supreme Court saying no, since RERA is a beneficial legislation, we will not have ADR. So I think we'll leave with the thought of whether arbitration is a beneficial legislation or not. Thank you so much. We have a very short tea break now. We'll be back here at 11:45 sharp, please, for the next panel. Thank you so much.